Okay, so good morning, everyone. Welcome to our webinar today. It seems to be a nice, crisp winter's morning. So I want to particularly welcome you to which I believe is going to be a very warming subject for all of us today. It's great to see so many of our colleagues joining us today. So our hearty welcome to everyone. The webinar today will continue in a series of webinars the EPA has hosted over the last 2 years. I've seen many of your names joining us for those webinars, so today will not be a new experience for you. It almost feels like today's webinar has been building up to a grand finale, given the quality and professional standing of our speakers today. But I can assure you that it's certainly not the end of the webinars. We're already planning for the next exciting one later in the year. But our speakers today are still arguably the best in their respective fields. You may have come to know our esteemed chairperson, Cynthia Skuman, over our series of webinars. She's clearly a face that we've all seen over the last few years. Cynthia is obviously the Managing Director of the Ethics Monitoring and Management Services. She's the chairperson of the Ethics Practitioners Association and sits on the investigating committee of IRBA. She has over 15 years experience in the field of workplace ethics and governance. She has developed practical tools and services to support the effective and proactive management workplace ethics within organizations and consults to private and public sector organizations. Cynthia is a published author of many publications and books in the area of workplace ethics. I'm not going to even try and give the list. I mean, we'll be here till tomorrow. So welcome, Cynthia. Thank you very much for that. As our special guest today, we've got Dr. Janet Minnaar, the founder of ProEthics, which promotes professional ethics and responsible governance practices in the public and private sectors. Obviously, a legal experience as an advocate with a PhD in criminal law allows her to develop and present training courses in the areas of anti-corruption, the requirements set by local and international corruption legislation, and the duties of directors, management, and staff. I'm sure you'll agree with me that we have two absolute experts in their respective fields. Cynthia and Janet are going to talk today about the new code of good practice and prevention and elimination of harassment in the workplace. You may have seen the headlines in the media lately about the code and the possible impact it will have in the workplace. But our speakers today are going to unpack this for us in a very practical way and give us some insights into what it means for us as practitioners. So Cynthia, Janet, welcome to you and over to you.
Thank you, Stefan, and thank you as always for your kind introduction. And Janet, can I also say welcome and lovely to have you with us and to share your insight around this. I mean, let me start at saying, you know, as Stefan has already commented, I think we're all aware of the Code of Good Practice that was only issued now and became effective only in March this year, and issued, of course, in terms of the Employment Equity Act. And I think as a starting point, you know, we're all focused on ethics and our ethics practitioners. And I think we'd all agree that not only the prevention and elimination, but also the management of harassment in the workplace, I'm sure we'd all agree this is imperative. But, you know, the devil does lie in the detail. And so let me perhaps start off by saying that, you know, the code is a new piece of legislation, but it expands significantly on the Employment Equity Act. Janet, what's your comment in that regard?
It does, Cynthia. Thanks so much for having me today. Morning, everybody. It does expand significantly. The code has a great intent because I'm sure we all agree that all forms of harassment anywhere should never be tolerated in any way. So the principles of the code, however, as we would know, since it's so new, has not been tested in the, you know, the CCMA and of course the various courts. So at the moment, it then implies and leaves us in the space to say, we can share our opinion on it today. And you know, I think the reason you got me is I'm the only one perhaps brave enough to take it on and try and put some some meaning.
Well,
to the
there's
word.
also that small matter of being an advocate, but anyway.
I try. So yeah, so I'm going to try and interpret it as best as I can from a legal perspective, but as a sort of a disclaimer, ladies and gentlemen, please don't see it now as fast in concrete or as a formal legal opinion. You know, these are just for us now to post some of our ideas, also in the context then of the broader field of ethics. And we always had that sort of contrast possibly or interaction between what the law requires us to do and what we know to be ethical and what's possible in that respect. So yeah, but the code has great intent, and certainly there were some ineffectivenesses, if I can use that word, in the act itself. So yeah, we're excited about it.
Yeah. Janette, starting off at a broader view, I mean, one of the issues I think that our audience will be aware of is that harassment was not very clearly defined in the Employment Equity Act. So that's perhaps a good place to start. In terms of this new code, how is harassment defined?
Cynthia, I've read the code, and I'm ladies and gentlemen, I'm going to do the one thing that one never supposed to do. I'm going to actually read from the script, because the law is about every word has meaning. So I don't want to just go and change it. So basically, the code now distinguishes between harassment and sexual harassment, and then it also speaks about the prevention, of course, of racial, ethnic, social origin harassment, which I like. I like the word social origin.
Yes.
You know. So workplace harassment now is inclusive of bullying, and it's regarded then as a form of unfair discrimination. It amounts also, as we know, to an abuse of power, typically in that sense. So the code defines harassment now, the definition as unwanted conduct, and that word we'll speak about a little bit again, and which impairs the dignity, creates hostility or an intimidating work environment for one or more employees, or that is calculated to or has the effect of inducing submission by actual or threatened adverse consequences. So you can see it's a full definition, but that's the formal definition. So it also speaks a little bit about the harassment not having to be physical only. We'll speak about that. It includes physical abuse, psychological abuse, emotional abuse, sexual abuse, gender-based abuse, and of course, racial abuse.
Yeah. Janette, that's great. Again, coming back, you know, expanding on our focus on types of harassment. You know, I think I say all, but you know, the vast majority of organizations in their regular company policies would have addressed the obvious forms of harassment. But again, I think a noteworthy feature of the code is that it extends the range of behaviors that constitute harassment a lot. Won't you touch on that?
Yeah, I will. And so in other words, it places an onus now on employers to go back to those policies.
Yeah.
And to then literally do a bit of a comparison. Where are we missing out on certain important aspects that are now addressed in the code? So it recognizes that harassment may be, of course, the result of physical, verbal, or psychological conduct. So the three, well, let's call it the main forms then. Physical harassment would include physical attacks. Now, again, interesting point. Remember, a physical attack is assault. It's a criminal offense in our country, and there's strong jurisprudence on that. When is something assault? So again, we don't have to use the code. We can also go to the criminal offense itself. And of course, any person who's a victim of assault can go to the police.
Yeah.
It also then includes simulated or threatened violence. That's interesting. So even the threat, a gesture, you know, shaking your face at someone, pulling whatever, even that could be regarded in terms of the code as a form of harassment. Verbal bullying may include threats. Again, the threat, you know, I'm going to fire you. You're going to not have an income, those type of things. Shaming a person. Hostile teasing. Interesting one. So be careful of those jokes. Insults, constant negative judgment and criticism. Of course, racism, sexist, LGBTQI and phobic language. The type of comments, the language, the jokes, verbal harassment then can happen through also online technology. The typical cyberbullying that we know about. and bullying and intimidation itself. Intimidation is a special crime in our criminal law. Now, it stands on its own. It's also a criminal offense that are used in respect of harassment is included in the act. And then, of course, bullying then referring to coercive power by an individual that uses that power, or even a group of individuals against a person. And then the last one, psychological harassment in the workplace, is associated with emotional abuse. It involves behavior that has serious negative implications for another person, psychological consequences. For example, we can think, verbal, that constant negative criticism, etc., and so on. And then they use a nice word called mobbing.
Yeah, that's an interesting one, Janette. I'm not, I appreciate it's in the code, but it's not something I was familiar with beforehand.
Yeah, so mobbing is a form of harassment by a group of people that is targeted at one or more specific individuals.
Okay.
And you can typically expect that for a group of employees that is doing that to a manager, because the manager may be strict, disciplined, and they don't like that.
Yes.
So that would be a form of mobbing. Interesting one.
Oh, wow. Wow. That is interesting. And again, I think a reflection of how the code has expanded what we need to be aware of. But before I move on to the next question, I just wanted to repeat a point you made, and a practical point that shouldn't be lost, that this code definitely warrants that I would say all organizations need to, at a practical level, review their current policy to ensure it's aligned, that it's not a case of business as usual. This alignment, as I say, this is from March until now that it's been in effect, but there are, as this discussion points out, so many changes that's a practical step that definitely needs to happen.
Yeah, and it's going to take some hard work, actually.
Yeah, I mean, as you said, I know when we were discussed, when you were reading the code, it's really very complex. It's not as straightforward as we would, like to think it is. But coming back to expanding sort of broad level discussion, when we look at, why was this code enacted? I asked that, but can I add a rider to that question as well? And that's as regards the approach around the primary remedy for victims of sexual harassment being to treat sexual harassment as an incident of unfair discrimination. So sorry, I'm giving you two questions in one.
That's a great question. Thanks, Cynthia. So before this new code, as you say, the primary remedy available was in terms of section 6.3 of the Employment Equity Act. And it treated sexual harassment then, as you say, also as an incidence of unfair discrimination. However, the impact of that actually is problematic to link the two together. So, and that what we also saw now recently in some of the CCMA cases and rulings is that sexual harassment is actually significantly increased. It's interesting. So, and in terms of the number of sexual harassment cases that has been reported. So the code really is timeless, So what those victims of sexual harassment could have done is they could refer it to the CCMA for arbitration. However, it's challenging to meet the standard of proving the unfair discrimination in the court, and the damages in terms of the legislation is limited to either actual damages that you suffered as a result of this discrimination, or a maximum of 224,000 rands and a few cents, whichever, is the greatest. So there was a bit of a limitation in that, and especially the burden of proof to meet those requirements made it difficult. And then, of course, the practical implication that many, victims would fear some sort of victimization if I do approach the court with this. And of course, my career, future employment possibilities, then keeps me from doing that.
And which, of course, I think that despite the code, is still a very real factor in our workplaces.
Yeah, so you're right. The code is not automatically going to solve that problem. There's a much greater ongoing discussion after today about how do we create an environment of psychological safety
Yes.
for people like those to come forward in an environment without fear of victimization. Right.
Exactly.
So another impediment was that the labor law are inapplicable of cases involving sexual harassment by third parties.
That's also a real feature of this code.
Yeah, a contractor that comes in and makes comments and those types of, uncomfortable things. So the code expands that now and includes any form of harassment by a third party. So that's great. And effectively, it then puts into play what the Constitution envisages with, fairness, equality, dignity. So the code does try and bring that protection against violation of dignity into play with that, right? So the code then also places sexual harassment in a broader framework, and the various forms of sexual harassment then are specifically named. So that's great.
Yeah, Janette, one of the problems around whether the conduct was unwanted is how do we, what is the testing law that it was unwanted, and also in terms of the code referring to a pattern of behavior. And let me interject before you answer to say, I really should have said at the outset to our participants that Sarah is of course managing the chat function, and we would obviously welcome your comments. We'd welcome your insights and certainly your questions. So please go ahead. It's intended to encompass that as well. But coming back to the question, as I say, what is that test for what constitutes unwanted? Your unwanted might not be my unwanted, and that pattern of behavior.
I like that about the code, that it gives us sort of a test. It is, although still fairly complex, to prove when behavior was unwanted. That's a specific word. Let me explain it a little bit. So the code requires that the complainant should have communicated either verbally or otherwise. Now, otherwise could be turning away, frowning, don't touch me, that sort of. So that's a non-verbal cue that I'm giving to someone. So either verbally or otherwise, directly or indirectly. So that indirectly could even be through a third party to say, what, I saw, you touched Janette, blah, blah, blah. She wouldn't like that. Perhaps it's not appropriate. So directly or indirectly, that your conduct is unwanted. I don't want this. I don't like this, right? However, even if this was not indicated at all, I said nothing at all, I didn't frown, I didn't do anything, then the code says it should still be determined if the perpetrator knew, which is a subjective test, of course, I know that this is inappropriate, or then it adds an objective test, should have known. That's a legal term concept, so the reasonable person under the same circumstances would have known that, Janette, you can't make those types of comments. It's just inappropriate and unprofessional. So, in ethics, it would be unprofessional. You don't do that. And then also that person knew or should have known that such type of conduct is generally considered to be unacceptable. Right. So the issue that it leaves us with is that the view of the harassed person may, in some instances, not be consistent with the reasonable person under the same circumstances. So, a very sensitive individual, etc., and so on. So that's quite interesting. Perhaps we have time to say something about that a little bit later again. Then in terms of the pattern of behavior, I also like that, because sometimes it's not one big incident, but it could just be little comments, little remarks, little jokes, little insinuations. That's a pattern. So it says harassment may occur as a result of a pattern of behavior, and it is not imperative to prove the intention of the harasser to show that the conduct actually amounted. But that's quite an interesting one as well. So it doesn't require intent at this stage, but you just, this pattern, the way you're communicating with this type of behavior towards this person is just inappropriate. Remember, it's not only females that get harassed.
Indeed, and we should remember that. In that regard, I thought it was noteworthy that the code specifically recognizes all forms of harassment against women, men, LGBTQIAI+. And so I think that very inclusive approach is really sound.
Cynthia, there's another little add-on in the act that I want to highlight that I also find quite handy. It says, when an investigator now looks into this case, was it unwanted? Is it possibly a pattern of behavior that amounts to this unwanted conduct? Then that investigator could consider the context of the harassment, the circumstances of the complainant, a very junior person, perhaps, the impact that it actually had on the harassed person. In other words, again, the test then, is it in line with a reasonable person in the same position? And then, of course, the respective positions of the harasser and the harassed. You know, a very senior person, if that happens towards a very junior person, it would be seen in a more serious light as well, because that's also, as you can imagine, clear abuse of power. And I have
exactly.
And if you tests to apply.
Yeah, and Janette, I know that you've referred to it already, and before I move on, this issue of proving intent, I mean, in general, in law, isn't that something that is required?
Yeah, it is, Cynthia. So it's something that concerns me a little bit. I don't just see it in this code. I see it in other sort of types of legislation as well. So in a criminal court, remember, the burden of proof is beyond all reasonable doubt, which is not the same as in a disciplinary on a balance of probabilities. But still, there are 5 basic requirements to prove that someone is guilty of a type of a crime, of a wrongdoing, an offense. And one of those refers to guilt. Before, I must have had some form of wrongdoing guilt in this process. It can't just be accidental. So in other words, either I was intentionally deceiving you, misleading you, lying, stealing, corrupting, or I was negligent. Typically think of culpable homicide. I negligently went too fast in the rain, etc., causing the death of another.
Yes.
Murder, intentionally causing your death. So that requirement is almost done away with here. So the person who has a pattern of behavior, quite innocently not realizing, this is giving an offense, it's attaching the person's dignity, it may be regarded as harassment or even sexual harassment, may find him or herself in a position where, wow, I'm in trouble. And it brings me back to what we love doing, teaching, training, empowering staff, managers, everyone to say, guys, be careful of this. Note, it's not acceptable anymore.
Another point I wanted to expand on when you were speaking about unfortunately, the ongoing problem around people being reluctant to speak out, even when there is genuinely a situation against them. I think, interestingly, in this code, the focus on a hostile working environment speaks very nicely to that point as well. How is this defined, Janette?
So again, the provision in the code dovetails to me very nicely with the Constitution, Section 25, that says it speaks about everyone has a right to a safe working environment. In other words, an environment that's not harmful to one's health or well-being. So we've all picked it up. You walk at a company and you realize something happened here earlier today. There's something in the air. Now imagine if one consistently has to work in an environment like that. So the code defines it as a hostile environment will be present where the conduct directly or indirectly impacts the dignity of one or more of the employees, and it affects that person's ability to perform their well-being, to do their best. Indirect harassment also occurs then when the conduct, even though not directed at a person, causes that same effect, undermines the dignity, the well-being. It threatens my safety, that feeling of this is a good place to be. And it is also possibly present in that hostile environment where the employers should anticipate that employees will be subjected to abusive conduct by third parties, members of the public, for example, customers. And that employer fails to take steps to protect that employee. That's quite an interesting point as well. We've had cases like that.
Yeah, but Janette, I mean, a number of things come out of that, but we've referred to this third party before, and one of the obvious challenge that certainly occurred to me is, how can the company effectively exercise authority over some external third party?
Yeah. It's a lovely question. So there are cases where an employer can incur vicarious liability The Prevention of the Combating of Corrupt Activities Act is one of those examples. So again, there is a space for that. However, to me, it falls in the sphere of ethics. Isn't it an ethical duty for an employer to ensure that third parties don't violate, the well-being of our staff? And we had a lovely story of a client of ours, man of integrity, very committed to ethics, did lots of ethics training for them. And they were selling, they retailers, right? So they had this one customer who had the habit of coming into the offices without following procedure, placing the order in advance, etc., and so on. And then, of course, things wouldn't be ready immediately. And he then would shout and scream, etc., and so on, much worse even at the staff, and they felt this customer, we're reliant on the income, etc., and so on. So we contacted, they didn't complain about it, but they didn't take the person on. And when this came to the attention of the CEO, he instantly took action, called in the customer, explained the value of respect that they live up to. And he said, I'm sorry, I have to dismiss you, even though you're only a third party and got fired. And I thought, what an example of strong ethical leadership, and really ensuring that there's a safe working environment. I love that.
Isn't that's an amazing example, Jeanette, and certainly not quite as powerful an example. I know that our company, I'm sure yours and many of our participants here would have encountered where organizations are increasingly asking suppliers to the company to sign a supplier code of conduct. And again, at a practical level, where we're looking at that supplier code of conduct, we should be updating it with the provisions of this code. And I also wanted to add, from our side in our organization, around the practical value of this, we were dealing with a client, very problematic situation. We were running ethics focus group sessions for them around a lot of problems. And I must tell you that the problems literally all fell within the scope of this code. I mean, when we talk about a hostile work environment, and so we were able to say the code is providing such sound guidance that one of the remedies was, in fact, as the code requires, was to provide detailed training on this, to say, let's be clear around what our current legislation says. And it was a very sound foundation to move forward. Yeah,
love that, Cynthia.
Yeah, and I mean, one of the other things about the code that I think almost prompts the title of this, where we looked at the title, I'm trying to think of the exact wording of saying, of course, the elimination and prevention of harassment is imperative. But does the code go too far? And I think when we ask that question of does it go too far, I think often what we're thinking of is the inclusion of passive aggressive behavior as a form of harassment. And I know when I read that and I thought, oh my goodness, how do we actually manage to implement some of this? What are your views here? And I mean, what all does this include?
Well, it's good. It's good that, there's an attempt to address this. And I'm going to read you the paragraph because it's good reading. I remember I was about 18, 19, I started studying law, and in our first criminal class act, our lecturers explained how the legislator wanted to, in this particular spot, make sure that no one has a house there. It's illegal, it's protected area, etc. And as they legislated that you cannot put a house here, or a dwelling, or a tent. What about a caravan? So I mean, these words just kept coming. Instead of saying you can't build anything or live here. So and there's a little bit of that in here. So it says, the code says passive aggressive or covert harassment may include the following: negative gossip, negative joking at someone's expense, sarcasm, condescending eye contact. That's the one, rolling your eyes at someone, facial expressions, gestures, mimicking, to ridicule, deliberately causing embarrassment and insecurity, invisible treatment, marginalization, social exclusion, professional isolation, and deliberately sabotaging someone's dignity, well-being, happiness, success, and career performance. So we agree, none of those things are acceptable in a professional work environment, in any workplace, right? However, what we did see in recent CCMA cases, there was sort of a move towards a purely subjective test on the survivor's perception. Now, this can be problematic because we can have that overly sensitive person, who deem harassment in, I just sort of raise my eyebrows and now, the person claims that I am passively aggressive, etc. So there is a danger in that, It could also be abused. We've seen that of staff members wanting to get a boss in trouble, so they sort of make up and they're very sensitive and sometimes it's miscommunication. So there are risks to this. It's a good intention, but there are risks. Again, I do think it would be important to then apply the objective test as well. Would another person in this position also have experienced it as aggressive, passive aggressive behavior? And again, should the harasser have known reasonably, that, Annette, you can't, when someone speaks to you, raise your eyebrows,
No,
so,
I'm raising mine to you.
Exactly, so again, isn't it perhaps just more prudent to put it in the ethics framework to say, guys, respectful behavior?
Yes.
What is respectful behavior? Then unpacking that, yes, do you have this in your policy by all means, but also unpack it in practical terms. What does it mean? How are we going to show respect to one another?
Yes. I mean, I hear what you're saying, but I think that issue I think there are two problems here that really loom quite large for me. One is, as you've already raised, the very sensitive person, and that my direct response, they're seeing as cutting sarcasm, and I'm thinking, no, actually, and also add to that, and perhaps to look at not only the very sensitive person, I'm also aware that especially in South Africa, where often our workplace is made up of many languages and many cultures. And so for me, still that risk of someone else's I don't know, condescending eye contact, to you might not even have noticed it, and to Mary over here, she thinks this is a massive problem. I do still see the issue there. So one is around the very sensitive person. Now, of course, I'm identifying three areas. One is around the very real language and cultural differences that exist in the workplace. But the third issue I'm seeing, which you've alluded to already, is the fact that this can be used maliciously. That you can now, claim to be, desperately offended because of someone's facial expression.
We've experienced that. Cynthia, we do ethics investigations, part of what we do, and we do see a bit of a pattern sometimes where younger people, would say, and I mean, in the end, we find absolutely no evidence. Because if you do make those sort of serious accusations, there has to be supportive evidence. Was there a witness? What did the person you say the emails, are disrespectful? Give us examples, and they simply can't supply those examples, and it costs the company money to investigate those cases. And one little story of how a client of ours sat in a training session of mine where the managers were also present. And at one point I was discussing respectful communication, and she raised her hand, and I could see she has something urgent. And she turned around and she pointed to the back of the class, and she said, they, in other words, referring to the managers, called us. So immediately there's a problem. It's them against us. Horses, she says to me. I said, pardon? Yes, they called us horses. And I, being a lawyer, I said, well, tell me more. And she said, the manager came in, we were working on a deadline, we were a bit late, and the manager said, guys, stop horsing around like this, we're going to miss the deadline. Can you believe she called us horses? And can you see what happens? Pure cultural communication, misinterpretation. Now, this is an interesting, no piece of law could actually resolve. Had there been an ethical culture with ethics talk, that freedom, she should be able to go to the manager and say, Yannick, what's wrong with you? Why are you pulling your horse? And I would then explain, it's a metaphor and so on. And the whole issue would have been resolved. But clearly, she took offense And she had a grudge.
Yeah. Sarah,
So that's going to impact.
Yeah, Sarah, I think you have a question.
Yeah, Ned, that's a wonderful example. But so actually we've just got one question here, and one comment, I suppose, that I think relates to a lot of what you've just been talking about. And we've got someone who's commented that call center staff come to mind when we're talking about.
Sarah, you're breaking up a little bit. Perhaps if you switch off your camera.
Is that a bit better?
Okay, go again, please. Yeah,
So,
please do again.
The comment was made about call center staff who come to mind in this instance, who often verbally abused by clients. So, in the process of literally making the cold calls that are literally part of their job description. Now, what could companies do in this instance? I mean, I think that's one very good point. And then another comment around, how do we actually build how do we approach training managers? How do we actively approach training managers so that we're creating harassment-free environments, so that they're conscious enough of what this what this means in terms of their actions and also in terms of managing their staff, I suppose?
No, starting with the first one, perhaps I'm going to leave the second part to Cynthia, but you were saying about the staff, the call center staff. And funny, that was an example that immediately came to mind, when I read the code. And I think one simple answer for me, and it's not simple, but give your staff permission to cut a conversation short. Coach them. There are many of how do I deal with aggressive behavior? There's a skill. You can teach a person certain skills. Sir, if you speak to me like that, I have no option. I'm going to cut this call short. Sir, I hear. I'm sorry, you're not stopping. Please call back at a later time. I can hear you're upset. Bye. To put down the phone. Give them permission to do that. Because remember, also culturally, younger people sometimes say, Anita, I can't say something. She's older than I am. It's really a practical thing, and we have to give them permission to speak out. They're the same as, I don't agree with you, Janet, even though you're my boss. That's a good culture where I have the opportunity to be heard. So yeah, Cynthia, the other one about the managers.
I think it's a core issue that applied even before this code. How do we get managers, leaders? And here, let me comment on why we would focus on them, because by definition, they exercise positions of authority and of influence, and they are therefore able to create, among other things, a toxic work environment. So this should have always been addressed. How do we avoid harassment? How do we create a pleasant and ethical work environment? And I think if we chose just 2 words, we could even go with just one. And Janette, you used it earlier. What constitutes treating someone with respect? What constitutes respectful behavior? And I would add one other factor, because I think it is a core feature of our society. What constitutes fair behavior?
Yeah.
And again, fairness taps into that. As we're well aware, there are huge areas of inequality in our society. And so fairness, it then of course translates into action. Are we consistent in terms of how we treat issues? So in avoiding harassment, if as I say, we focused on just those 2 things, of course there's a lot more, but as a core foundation, if our managers and leaders are saying, here's the new code, there's no magic wand, but to the extent that it's a magic wand, if you are genuinely treating people with respect, and if you are genuinely treating people fairly, I think you got it. And again, I think that the trap organizations can fall into is not drilling down into this enough. And that's where I think now, for example, your example of horsing around, that's where I think examples can be so very illustrative and informative of, and then having that conversation in the workplace. what would feel disrespectful to you? And when that is as part of your ethics training, as part of your ethics conversation, what would feel, uncomfortable for you? Here we're now starting to create a pathway where we're eliminating the misinterpretation that I think can still arise. So I think not a magic solution, but a very sound approach. Yeah. I wanted to pick up, Janette, where you left off, where we were talking about passive aggressive behavior, and specifically taking that example you used. And almost the trap that managerial action can then almost be labeled as harassment, especially if, for example, I don't like it. So, I mean, that's an interesting point because, does the manager now, I'm speaking about respect and fairness as an approach to eliminating harassment, but, the manager, the leader has still got a very real role to fulfill. And that trap of it all now falling under a ban of harassment must be very real.
Exactly. And I love the fairness principle you just highlighted. But because surely how unfair would it be to a person if the person never receives any feedback? There are no appraisals, there's no evaluations, because I, as your manager, I'm too scared to say anything because you're so sensitive, you may regard it as harassment. I might end up as, in a disciplinary. So there's an interesting interaction between that. So in line with fairness, when a person raises a different opinion, be it the younger or the older person, doesn't matter. That is not a form of harassment. It's aligned with equality and openness and what we want to encourage in, the social contract that we have. I can speak out. I may be different. It's okay. Or a manager that provides constructive feedback. Now, some people will say there isn't something like positive criticism, but feedback is feedback. And sometimes I do need to hear what I need to hear. It's for my own best, my own, improvement. When I'm making a complaint in good faith about a person, doesn't mean I'm harassing the person. It means that X, Y, this, that did this or that, or missed that, or misrepresented that. It's a good faith complaint. There's a process. That the company would follow in terms of, reports of wrongdoing and so on, where any sort of, again, the test for reasonableness, management action is taken. And that would include decisions regarding job duties, work to be performed. If it's part of your duties, you're not doing it, then I have every right as a manager to say to you, Janette, you keep on being late, we need you to man the phone. Workloads, deadlines that are set, layoffs or transfers. Again, we have a very good labor process, that deals with those things. And as long as we stay within those framework and guidelines, that's allowed. Work instructions, supervision, work evaluation. Janette, this is where we can improve. All of those things are acceptable. And then, of course, even discipline. As long as the substantive and procedural discipline, the code, and all of those things apply. It doesn't mean that I have been harassed because I was disciplined.
Yeah, good, but I think that's important to remember. Sarah, I'm sure you've got a question.
So I've got a great question, actually, and I'm not going to camera on and try and talk, but I've got a great question. On perhaps a lighter note, to quote exactly from the chat, can emojis also constitute harassment? Great question.
I think that's a great point because so many of us, whether we're using a WhatsApp or other messages, or even increasingly even on other forms of communication, emojis are used a huge amount. And Janette, I'm going to hand over to you to comment, but for me, I was reading recently that, I don't know, there were only 16 new emojis issued in the last period, and everyone was a little outraged. I don't know, I assume it should have been many more. And I will pass this comment, and for all of you, I will add the qualifier that the comment is probably age related. But I look at a number of those emojis. I've got a smiling face. Yeah, got it. But I look at many of them, And I am not absolutely sure what the meaning is. And in fact, reading about it just recently, there was a very interesting comment, so it's not only me, around the completely different interpretation of various emojis by different age groups. And so much as I think it's added a fun, perhaps light-hearted element and a quick communication, I think for me, it certainly lends itself to misinterpreting. But as I say, this is a recent report, within the last week or so. Yeah.
It's I'm an emoji lover. You'll get the kiss and the heart and stuff like that.
Yeah, but I care about those.
Cynthia, you also care about the eye roll.
Yeah. Thank you, Sarah. So we had an interesting case about a group WhatsApp group. So these are employees working in the same team. You have to belong to this WhatsApp group because practical things are organized. The meeting has been postponed for half an hour, etc., and so on, especially when you're working remotely. It's a quick way of communication. Yeah. You might not be right at your desk by your emails. So this is just to let you know. It's a practical thing. All work WhatsApp groups are managed by an administrator. The moment the administrator sees something inappropriate that may be misinterpreted, be it by a younger person, a different background person, etc., it's up to the administrator to say, Janette, privately, that little thing that you put on, you know what, it might be misinterpreted. Rather refrain. So again, we're so dependent on one another. We need one another to sensitize us to certain things. I've made myself guilty of once in a very big conference using a word that I genuinely, as an Afrikaans speaking person, did not realize the real meaning behind. I really didn't. And so I use this word. And fortunately afterwards, caring, colleagues, they said to me, Annette, this is, I was highly embarrassed. But again, fortunately, I was, corrected in a kind way in private, and I was able to avoid it going forward. Same with emojis. We don't always know everything. We need each other to help us.
Yeah, Janette, that's such a sound and practical response of saying that I mean, I've been part of work group WhatsApp groups, and to recognize the importance of an administrator to just oversee it, I think is such a clear and practical approach. I mean, that does rather lend itself to another more serious issue, because of course, I know we touched on bullying and mobbing, but cyberbullying is also a very serious issue.
Yeah. So, it's one of those areas where parents need to get themselves informed. Right. So, and we had a case that we investigated through a big client where in this WhatsApp group, 2 of the participants to the group started making certain jokes. It wasn't so much bullying, but it was inappropriate. And a long story short, it actually ended up in a sort of a child pornography question. So, I was amazed at how far it had gone. And it ended up as to say, I need to investigate, this is chaos, what should be done, what should have happened, what didn't happen, what must now happen, etc. And it's the same with cyberbullying. It very quickly takes on a life of itself. And it's one of those areas where I would say be very quick and strong in your response. You say, this is not on at all. Again, it's up to, the more senior person in that case. And also, again, encouraging our staff, getting that environment where people feel safe to come forward to say, you know what, I saw on the Facebook of so-and-so, my colleague, that she's making comments about our team or about me, come forward, tell us so that we can address these issues. By the way, even if it's your private WhatsApp account, your private Facebook or Twitter, whatever it may be, you are still in obligation towards one's employer and, being a loyal and respectful employee. You can't just say, legally it's been tested several times. You cannot, your freedom, your right to freedom of expression is subject to being a responsible employee. You have other avenues. If I don't like my boss, take up a grievance, go address it with the person. I can't just say what I like about the person and then claim it was my private opinion. Sadly,
Yeah, I think that's a very big factor that all too often we don't recognize applies to employees. That as I say, even a freedom like the freedom of expression has got its limits. It's not entirely unlimited. So I think a sound point there. I mean, coming back to, I think that one of the key issues in the code is not simply the expansion of harassment, but sexual harassment remains such a core issue, sadly, in our society. And I know I already asked you about the intent, but I mean, do you think it warrants just touching on again, what are the factors to establish sexual harassment? And I think you have touched on that, but for me, that is unfortunately such a problematic issue in our society and hence in our workplaces often.
I, as an emancipated woman who's happily married, I'm still amazed that this happens so often. You know, so sadly. So the code, creates a grid for us almost, and it says there are 3 factors. First, was the conduct unwanted? Remember, the fact that I consented to certain conduct a month ago doesn't mean it's ongoing. Okay. I can withdraw my consent.
Okay.
It's an important factor. Secondly, what is the nature and the extent of that conduct? And then last, does it fall within the definition? And then lastly, what's the impact of that conduct on the complainer? Now, that's the intent, etc., and so on. So let me quickly unpack them. Unwanted then is described as the following. The different ways in which an employee can indicate that the sexual conduct is unwanted. That's the non-verbal turning away, etc., and so on, walking away, not responding. You know, I when I was younger, I had the habit of, I just pretend I'm not even hearing what you're saying. You know, so I'd literally just ignore it. And it worked extremely well. Where a complainant then finds it difficult to indicate to the perpetrator, be it that the person's very senior or I'm just a very shy, introverted person, I may also seek a third party to assist. Cynthia, will you go and chat to so-and-so? Right. Also, where the conduct is such that the harasser, the perpetrator, objectively ought to have known that it could be regarded as unwanted, it will still amount to sexual harassment, even if the person did not clearly indicate that this is unwanted. Okay. So the code says, well, implies, in other words, that no obvious intent, to commit this unwanted act has to be proven. And that brings us back to the criminal law, some form of a guilt. So we'll see how the courts then interpret that. But it, in other words, makes it, it almost expands it, So even if the person didn't say something, you, Janet, should know better. Yeah. You can't make those comments or do those things. Then in terms of the nature and the extent of the conduct, that includes anything of a sexual nature, of course, physical, verbal, non-verbal, conduct, whether it's expressed or whether it's direct or indirect. So the type of jokes, the little pictures that I send you that's inappropriate. Sexual harassment should be offensive to the complainant. Again, it's a subjective test, making that complainant feel uncomfortable. It causes the person harm, it affects my well-being, and it will inspire a reasonable belief that for, the investigator, that this person will be harmed by this type of conduct. It's not appropriate. The nature and extent also says that it may interfere with the work of the complainant. Okay. It doesn't necessarily have to do so, but it may. I'm so scared. I don't want to come close to this person. He's my supervisor. So what I'm doing is I'm avoiding him or her, and I'm not asking for guidance. I just rather do what I think because I don't want to be in this person's company. Yeah. And then it also will violate the rights of the employee and obviously constituting a barrier to equality, as you can imagine. So that's in regards to the nature and the extent. And the last one, then the impact that it has on the harassed, the victim. It requires that the conduct should create an impairment of that person's dignity, taking into account 2 things: the circumstances of the employee, it could be a junior person, it could be whatever it may be, and then the respect positions, again, of the employee and the harasser in more seniority, etc., and so on. Again, making it more likely that the person might have abused his or her position. So interesting how the abuse of power, seems to be the twin of this as well.
I'm going to try and, I wanted to conclude on a positive note, but I'm going to see if we've got time to sneak in one question before that. And Janette, well, maybe it's more of a statement. Because I certainly recognize that when we're dealing with problematic issues like this, with harassment actually of any kind, including sexual harassment, that where an objection, where a formal complaint has been raised about it, yes, of course, we would like to always assume that it comes from a very genuine place and has genuinely happened. But we are raising that it can be a false claim that is being used in the most negative way to be damaging to a boss who has, I don't know, incurred the employee's displeasure. And so I almost want to make as a statement that while our automatic response to protect victims of harassment to the fullest extent, I want to emphasize your point of doing those investigations and doing them by an external party, such as, for example, yourselves, that all of these cases should not be responded to in a sort of knee-jerk reaction to immediately paint the accused in the most negative light. And as I say, given the prevalence of problems like this, it would be such an easy thing to do. We've got a lot of this happening and, this person must be guilty. And I just wanted to emphasize that, yes, these are sensitive issues, and we would certainly hope that there would never be a false charge laid, but we can't be naive to that possibility.
100%, Cynthia, and remember the basic principle in law. Each case, each complaint must be judged on its own merits. It's always whether, there's no general rule. So, and also, remember the Protected Disclosures Act clearly says in any type of reporting situation, the reporter has to act bona fide, has to act in good faith. So in our investigations, where this really transpires to be a malicious type of claim, to get a person in trouble, our recommendations would include that the person is then disciplined, the false reporter. And it is important that that role goes both ways. Please come forward, but you can't do so with malicious intent.
Exactly. And then looking at time to perhaps end on a positive note, although I think you've already highlighted a number of positives. What would you say is the main strength or the main strengths of this new code, Janette?
Well, I think the expansion of some of the definitions that we were not clear on, but certainly the fact that the code actually provides for guiding principles in terms of prevention, elimination, and the management of, of harassment, all the forms of harassment. But it's not just, this is wrong and this is wrong, but also how do we prevent this? How do we manage it had it occurred, sadly? One of the things that it says specifically, employers must educate employees to understand what harassment entails, all the forms of it. And I love this proactive approach. It dovetails again with Section 60 of the Employment Equity Act, that employers are under an obligation to prevent all forms of harassment in the workplace. So I love, ethics to me is about prevention, and this can then speak to that, to say, get these things in place, especially in terms of the conversations and the education part of it as well. People get themselves into trouble often innocently. We've seen that a lot of time. It's the minority, who go out and I'm going to harass you and so on. And that should not tolerate it in any view. But we also want to prevent, the person who innocently does something that's inappropriate. Let's educate them. Let's be proactive about this.
Yeah, I mean, so at a practical level, I mean, I'm taking out of this is the harassment policies and organization in light of this code absolutely should be reviewed. I recall in my own reading, not as in-depth as yours, is that the disciplinary process would also warrant some nuances to accommodate this, and that there is appropriate training and education around this. And again, if we look at those practical steps, it can go a long way, not simply to eliminating harassment, but of course to strengthening ethics in the organization. And you know, as a concluding comment, you know, let me say that we should recognize that all efforts to strengthen ethics in our organization, we should embrace. So I'm conscious it's 10:30. Janette, can I say on behalf of the EPA, thank you so much for your time, for your insight. It was really an absolute pleasure chatting to you. Stefan, over to you if you want to wrap up.
Yeah, thank you very much, Cynthia. And again, thank you very much, Janette, for a very insightful kind of perspective. I mean, I really took out of it that, you know, from an ethics perspective and the ethics practitioners, we should look at this at a proactive, from a proactive perspective, and make sure that people are trained, people are aware, and, you know, these type of things will not happen. And also, you know, at the end of the day, it's about respect, mutual respect. And I think that's the value that, you know, if you follow that value, you would probably solve a lot of these issues before it gets to a legal position. So thank you very much, much appreciated. Thank you to all of our participants. We hope that we gave you a very informative session today. All the best, and I'm sure, Janette, if you don't mind, if we get questions, we would be happy to relay it to you and share it at our various forums. Thank you very much, everyone. I hope you have a wonderful day. Thank you to our speakers again, and have a nice day. Thank you very much. Goodbye.
Thanks, everyone. Have a good day.
Bye.
Thank you. Bye.
Bye.